So our panelists today, I will keep this brief. They have extensive backgrounds. Uh, a barrister from England, Stephen Mason of Middle Temple in London, and he's the author of numerous books. And I'm pleased to get a couple of them here. The fifth edition of Electronic Evidence, Electronic Signatures. I also have, for those who are particularly interested in electronic signatures, he's got a fourth edition and I think maybe a fifth edition out on that. And I can say that these are great books, great reading on airplanes. So it's not just for practitioners. Our second speaker is George Paul, a well-known lawyer in the science and technology section and a author of lots of articles and books, including The Foundations of Digital Evidence, going back to 2008. And I still think it's not a typical textbook treatment of the subject that's more like Stephen Mason's. This is more of a thought piece, how to think about digital data evidence overall. And it is a fascinating book that is still about the best I've seen on the subject. And I'm hoping that the science technology section with the Risk Trust Management Committee will look to republishing it, bringing it back into print. It is available online. And as I mentioned, I'm pleased today to be your moderator. So our disclaimer today is all of the views being expressed are the views only of the panelists and do not represent the American Bar Association or any other organization in any way. I just want to begin with just to level set this. We have the key challenges with agentic AI. First, how do we know what's authentic or true or false? And there are many say that we can't pin that down. All of our rights are at stake, and the whole concept of discerning right or wrong is almost impossible. Second, informed consent about the agentic AI autonomous decision making. And again, agency law requires that a principal or user grant consent to the appointment of an agent. So it's fundamental to the law, and the agents must consent to the appointment. Of course, there are exceptions, like everything as to in terms of estoppel or apparent authority and all that. But this is a basic point that all of the software developers and companies need to put in. And I'm hearing that there are some who think this could be a liability avoidance mechanism to use agentic AI. But all it's going to take is one judge somewhere saying, no, agency law applies. The whole industry could come down like the Hindenburg, liability-wise. So this is a serious issue. And then finally, who controls the agentic AI? Is it the user, the principal, as it should be under agency law, or is it the some machine that's under the control of somebody else? Or where does that liability flow from that? So I'm going to turn it over now to Mr. George Paul, who's going to start call to action.
Well, yeah, we're looking at this slide. I think, we have to remember that technology in many areas advances exponentially, and most of us are familiar with this. There's Moore's Law, and with artificial intelligence, we're adding in the concept of software advancing exponentially. And we're at a point now where the technology and the businesses, which are motivated by money to make people rich, are racing ahead with these technologies. And because of the exponential growth, the legal system hasn't really been scrutinizing what's going on and how it implicates society. And so there are implications for business, for the courts resolving disputes, and for the national legislature, and for the larger culture. what are the implications of these artificial intelligence and how should the law respond? And given exponential growth, the law needs to respond kind of quickly. It needs to urgently address these issues. I don't think anybody will disagree with that grand summary. So what is agentic AI? I asked agentic AI this question, or I'll ask artificial intelligence this question, and here's the definition. It perceives its environment and acts upon it often without direct human intervention. Well, that part's been going on for years. I mean, who knows how many, 20 years? There's a Uniform Electronic Transactions Act. Computer programs can enter into contracts. They can sense their environment. They can, the price of oil's down $3, buy, okay? The difference here is there's this concept of perceiving the environment and then reasoning about it, okay? The computer, the system, the information system is supposed to be reasoning. It's supposed to be thinking. And I really think here is where technology all racing ahead without really thinking things through too carefully. This is where artificial intelligence is trying to kind of be human-like. This thinking, this reasoning. And this is getting to be very, well, let's look at the next slide if you don't mind, Tim. I found this by accident 2 weeks ago. The National Institute of Health 2 weeks ago said, hey, here's we're taking suggestions. We're going to be rolling out an institute-wide strategy, artificial intelligence strategy, that's going to build until we have self-documenting biomedical AI beings. Okay, I don't know if you guys can see the slide up there, but the federal government now is trying to construct biomedical artificial intelligence beings that are going to control your health. That's their goal. You have until July 15th to comment on that, and there's a 1-year action plan. So this is racing ahead. It's not just kind of theoretical. The federal government's trying to make artificial beings. So that demonstrates the topicality of this, the urgency, the exponential nature, and of course when you have exponentially evolving systems, you have transformations and sudden events that occur because of the non-linearities involved.
Now, George, I'm going to ask Stephen Mason. He wants to comment from his experience, just backing up a bit here with applying evidence in electronic form to these new technologies and what you're seeing here. What would be some of your general observations for that?
Thanks for asking me, Tim. First of all, I agree with what George has had to say, but I hope participants will probably accept that it's not surprising. I would agree. It certainly is true that the evidence in electronic form has generally been haphazard, the adoption of it in the legal sphere. There are quite a lot of judges and lawyers who have actually changed and adjusted their mindset, but actually quite a lot haven't. And I've had the privilege of meeting some US judges and lawyers, including George and Tim, of course, and also Tom Smethinghoff, who I've had the pleasure to know, who have adjusted and understood the remit. And to pick up on George's point about health in the USA, the same thing is happening here in the UK, but it's more secret. It's stealth. It's under the radar here in the UK. So these things are happening. And in fact, the new government that came in was actually lobbied by lobbyists for almost 8 to 9 months with a numerous numbers of meetings to try and encourage them to stop dealing with AI in legislation, which is quite interesting. Now, what I was proposing to do, Tim, a little bit later on is look at the technical evidential issues, but maybe just to follow on from George's point, which I think this is the most appropriate point for me to make some points now, is that there are a number of questions that I haven't got answers to necessarily, but nevertheless are pertinent. And I think these questions that you might have raised, and George and I obviously agree with these. So I'm just going to run through them very quickly and then hand it back over to Paul. To George, sorry, George. question: can autonomous agents with decision-making capability produce reliable evidence? Very, very good question. Can decisions of AI agents be legally attributed? Well, I totally agree with you, Tim. That's where the law of agency comes in with no question at all. How can they be reliably identified? Well, that's a problem that we all face right now. And probably most of the people, lawyers who are attending this session right now, know full well they've had examples of this in their own practice. Can you prove or test the authenticity of the actions taken by an AI agent? As it is, it's difficult enough at times to prove that just using general electronic evidence, and there's plenty of case law to demonstrate that. And then, of course, there's the question of consent. What does constitute consent when there's no direct human oversight? How do you allocate liability for harms, which George has touched upon? And, of course, how do relying parties, i.e., those of us, let's say, who buy something on the internet, how do we know on whose behalf the AI agents are actually legally operating? Are they agents? Are they representatives? So there's a whole range of things here which George has outlined by implication. At this point, Tim, perhaps it might be appropriate because those are questions rather than answers. And those are some of the questions that perhaps this group may be wanting to think about in the future. And I think it's probably now appropriate for me to hand back over to George and carry on from there. What do you think?
Yes, thank you, Stephen. I think these are going to be questions that will be involved certainly in a future webinar series, and no doubt other sections of the American Bar Association. So I will proceed to the next section. And also, Stephen, I do want to maybe at the after George's comments, the next section, you can get into a little more of the technical issues of evidence, hearsay, authenticity, so forth.
Yes, indeed. Yeah.
Yeah, Tim, I'd like to kind of cover two slides now
Sure.
as we move forward. Yeah, we in all digital evidence systems, and I see some of the people that are attending the seminar, and they're some of the top people in the world, actually, so I'm a little embarrassed to be talking to them. But these artificial intelligence systems, of which there are many, they're growing, they're complex information systems, and our whole economy is complex. I think there's 300 companies that have an input into an iPhone in several different countries. No one person at any of those 300 companies really understands the product, because each one of those components is the product of complexity. And so you have these complex systems that are trying to emulate human intelligence, okay? So, but and there's this big boosterism that we're gonna have artificial beings. But let's take a look at this study that was recently done. Tim, the next slide.
Yeah, George, my slide is frozen.
Oh,
so you'll have to think
well,
about it.
I can tell you what it is, and we can throw.
Sure.
The technologists at Apple about a month ago, I think, released the results of their study. They decided to oops, now I'm too big.
Go right ahead.
They did a study on what's going on with these large reasoning models. You have your large language models where they dump all this information in and try to train. They're sort of running out of information, and now they're dumping in information that artificial intelligence has created. Then you have your large reasoning models, which are trying to go one step beyond that with this reasoning idea, this thinking idea, this human idea. So these Apple engineers designed a rigorous series of tests on the most advanced of these large reasoning models, and what they found is that when they get to a level of complexity, there's just a complete accuracy collapse. Okay, they're just completely inaccurate, and they determined other things like they kind of can figure something out, but then they stop trying. They stop putting their resources towards coming up with an answer. So all this giant momentum about making machines into something akin to a human mind has been proven well. The reliability is zero when it reaches a certain point. And, this is a multi-page study. I just put the first page on the slide. So, big picture is it's not working, okay? And the next thing, since we don't have our slides, I'll try to mention this quickly. That was the article I was just discussing. It's very interesting because it's kind of a scholarly attempt to actually test the the reliability of these large reasoning models that are trying to inject this thinking as one of the foundations of this evidence that's going to be created. We're going to have all these foundations: authenticity, identity, timing, agency, and with artificial intelligence, these foundations are just multiplying. One of the most important is this reasoning. So let me just say one more thing on the next slide. There's a trend now that the more intelligent, the more smart these things do become, the more they start hallucinating. Okay, I think we've all heard that term. They're hallucinating more and more and more as they get smarter. And you talk to the people in the industry and they say, hey, it's getting worse and worse, but we don't know what's happening. We don't really understand our own system. They're always going to hallucinate, some of the experts say, and there's entire companies that are in the billions of dollars of value that have sprung up to try to cope with hallucinations. So basically, these people that are creating these very complex information systems that are trying to become more human-like, they don't even know how they work. They're creating all these hallucinations they can't get rid of. And so that's not very reliable. How do you test something that has a critical foundation of reasoning when the people creating that technology don't even know how their technology works? It seems to me that would be kind of dangerous to inject such a system into controlling the health of the people in the United States, including their mental health. Okay, so I'll quit talking now because perhaps.
Right. Well, thank you. So I'll turn over to Stephen. Even if you want to delve a bit into, you've written extensively in your textbooks and so forth on issues of reliability. Should the courts be just presuming reliability of by software code and so forth? So.
Yes, Tim. And if I may, after George's next point, I'll look at hearsay. But at this stage, a corollary to George's point, and I have read that article, The Illusion of Thinking, as well, and it's caused me to pause and ask myself, well, hang on, wait a minute. How do we think? Because human beings ourselves, we will sometimes make a decision and then we will set out a rationale for our decision after the event in the light of whether it's gone right or wrong. So that's not new. But George has hit on an absolutely fundamental point about here, is that people do not understand how this technology works. And I have just ordered, actually it's just come out, the book by AI Con, How to Fight Big Tech's Hype and Create the Future We Want, by Emily Bender, Professor Emily Bender and Alex Hanna. I'm hoping that it will arrive tomorrow so I can start voraciously reading it. As it happens, Emily Bender was given lunch with the Financial Times, and there's a big article about her and what she had to say over lunch in Saturday's Financial Times that went by. I happen to agree with her significantly on a lot of what she has to say, but the follow-on from what George has said, and I think this is crucial, is that there are two important issues from a practitioner's point of view, which are actually highly significant. The first is discovery. Discovery is absolutely fundamental. And if discovery of software code had not happened in the Bookout case in 2007, we would have never known how bad the software was in Toyota motor cars. And that really, really was a very important case. And I wrote to the judge in the United States and asked if I could publish his ruling, and I did. And he sent it to me, and I published it in my journal, The Digital Evidence and Electronic Signature Law Review, because that was not freely available on any database that I could find. But also, there's this reluctance to challenge evidence in electronic form. And I'm sure there are a lot of practitioners listening to us right now who will say, well, I do this every day. And of course you have to do. But interestingly, when you look at some of the case law, and especially the UK Post Office Horizon IT scandal in the UK, it's the worst legal scandal in English legal history. It was hardly touched upon electronic evidence. And because we have this presumption in England and Wales that computers are reliable. Absolute nonsense. It was established in 1997, and it's proved to be a total disaster. So we really do have to actually not only be more willing to disclose electronic evidence and software code in particular, but we have to challenge it more voraciously. And I certainly, if we've got time, be interested in some of the experiences of those people who are attending this event at the moment as to what they've come across in their practice, and how the judges are not willing to force disclosure of software code. Having said that, there's one caveat with that, and that is, of course, if we look at the big AI systems that George has outlined, the next question is, well, I can give you as much software code as you like, but it's going to take you 200 years to look at it. And we still don't know whether the solution is going to come out of there, and you're going to find out whether software code is right or not. And so that is going to be one of our fundamental problems as lawyers and judges generally. It's something perhaps your section might like to start thinking about seriously in the future. And what's also interesting is, just to finish off, is that although England and Wales has got this express presumption that computers are reliable, which is an evidential burden, which they're looking at right now as a result of the scandal that's occurred in the UK, and I hope they actually change it. I have been, and across a lot of European jurisdictions in particular, speaking to judges and lawyers over the last 20 years. And although they don't have any express presumptions, it is quite clear that judges have an implied presumption that computers are reliable, and hardly ask lawyers to test it, which is quite an interesting cultural observation. I don't think at this stage of the game I've got that much more to say, Tom. So happy to hand back over to George.
Well, yeah, I could emphasize one of the things you've mentioned. I think sort of the foundation of knowledge and the foundation of science is the ability to test assertions.
Yes.
And unless you can test, you can't determine whether something's true or false. Okay, and that's basically, a key to truth and knowledge is the ability to test. Now, there are information systems out there where the way they're designed, a lot of times unintentionally, you cannot test the assertions. Okay.
Yeah.
You have to self-consciously build a system. In my book, I called it eunomia, so that the system keeps enough information in it, like digital signatures and so forth, so that things can be tested. The authenticity can be tested. I am afraid that in this area of artificial intelligence, it's going to be very hard to test a lot of the elements that come out of the, quote, reasoning, come out of the decision, especially when you realize the people that are running the companies trying to make all this money, they don't even know how it works themselves. They throw a bunch of information in, they started communicating, they're hoping it's going to be a thinking thing, but something else may be happening. And that's kind of next thing I wanted to talk about after I punctuate Stephen's point with the testing concept. Do you want me to keep
All
going,
right.
Tim?
Well, and just finally, yeah, when I think about just again getting back to agency law here and agentic AI, so it looks like we're going to need what we all need is to build into the design the ability to test many levels here. The test the whether the principals have given consent, whether the agents, the agentic AI in some form, there's some aspect of agreeing, assenting to being made the agent with all the liability around that. The third parties need notice as to whether they're dealing with an agent that is an agentic versus, in terms of how, who's liable is they need to have liability on the principal. There are issues. So with that, the authority, proof of the authority of the individuals, proof of identification of all involved, and ultimately the proof of who's performing the various acts or executing agreements, so forth. So this can be done, and if it's done right, it could be ultimately great for individuals. And the whole concept of sovereign agency, which many of the data scientists are putting forward, so it's great.
Tim, do you mind if I follow on from just briefly on the point that you and George have just made? You're both right for obvious reasons in my view, but then I suppose there are two questions come up. My emphasis on discovery and looking at software is, of course, first of all, cost, which can be significant and could be disproportionate, which is a difficulty. And secondly, getting hold of expert witnesses, because you may not be able to get hold of the expert witnesses. And I'm sure some of our participants today will be able to discuss that as well. And so these are other issues probably that you have to discuss as a group, including maybe asking appropriately technical, knowledgeable people to actually aid the lawyers in discussing this point.
All right. Thank you, Stephen. And we'll leave hearsay
until next. Yeah.
Throw that in. So, George, back to you. The main dangers of AI, especially in this context.
Well, this is not a strictly legal issue. It's more of a societal issue. I mean, we've seen all of these hallucinations. They're getting more and more and more. They don't know why they're happening. They don't understand their own system. There's companies springing up to deal with them. I think there's something going on, okay? And if you want to think about for me, from like a cultural point of view, a societal point of view, an overall big picture legal system, you have to understand how complex systems work, okay? If there's one slide I would suggest you remember, and I'm trying to look at my own computer here. It's this slide right here of the danger of artificial intelligence. Artificial intelligence, because of all the flows of information that are communicating with each other, is starting to, in my opinion, okay, is starting to exhibit what's called emergence, okay? And this is how complex systems, I'm not ready for that, okay? Tim, can you go back? This article documents the fact that people are starting to ask AI systems, well, what does this mean? What's the meaning of this? And people started out, for example, someone said, well, hold on a second. What is you can't lick a badger twice mean? What does that saying mean? Well, the artificial intelligence system doesn't say, hold on, there's no such saying. We got to have all the data in the world. There's no saying like that. It doesn't say that. It says, well, you know what that means? That means you can't lick a badger twice. It means you can't trick or deceive someone a second time after they've been tricked once. It suggests that it's a warning that if someone's already been deceived, they're unlikely to call for the same trick again. Well, that's not what that saying has meant. But now, using this kind of reach or this desire to get a form of intelligence, all this information is allowing something new to emerge, which is something it's like its own intelligence. It's inventing what things mean. And hey, with the way language works, if the little if the AI computer says, well, hey, this is what it means, people start hearing that on the internet, going back and forth. Hey, that's what it means now. Because once people start saying it, once people start using those words, and that's now become a meaning. So basically, you have artificial intelligence through this emergence of novelty, creating meaning in society and influencing society on its own, okay, through emergence, which is kind of its desire to reach a primitive sort of intelligence. It's making up, sometimes it gets it pretty good, like the badger thing. Sometimes it doesn't do too well, like it says you should put glue on pizza because that'll keep the toppings from falling off, okay? But hey, a bunch of teenage kids might start putting glue on their pizza. So the concept of emergence in the artificial intelligence comes about because I almost put a slide in on this. A lot of information flowing through a network, and we have a lot of esteemed people in the audience, at least I saw them at the beginning. A lot of information flowing out and flowing through a network, including information in a bunch of people's minds connected through the internet and the cloud, coming together, will start organizing, will start emerging into patterns. And we see this with social media. We see things acting as catalysts or enzymes, creating structures, creating people thinking, creating groups. So I really think, given the way technology works, this concept of emergence is critical. And my own personal opinion is that hallucinations are sort of a subtle form of evidence of emergence in artificial intelligence systems. So I like the badger licking article, okay, that for me symbolizes the concept of emergence in artificial intelligence.
Do you mind if I interrupt here,
No.
Tim and George? Because that leads me on to the hearsay, actually, if that's all right with you, Tim.
Yeah, go right ahead.
Well,
Sure.
because having done a lot of talks to lawyers and judges in Europe, which of course is not common law system, whenever I talked about hearsay, they would all go to sleep. What they did is they would go onto their computer or their smartphone and start tapping away and do emails, while this English lawyer talked about something that they were not interested in because it was irrelevant to them. And that's why I coined the phrase software as the witness, which is now a separate chapter in our book, chapter 4. And Daniel Seng and I, between us, when we did the hearsay chapter, we looked at this in quite careful detail, and we established 3 categories of evidence, and I'd be really interested in people's response to these. So category 1, and this fits in precisely about you can't lick a badger twice, George, and I hope you'll follow me on this one. So the first category, briefly, excuse me, is content written by one or more people. So it's a record of an activity, which is usually a list of contacts, information about mobile telephones, text messages, email correspondence. Now, the only difference between paper-based documentation and that sort of record is how it's captured, created, captured, and stored. It's all done electronically. Now, as evidence, it may be necessary to demonstrate that the content of the document is a reliable record of the human statement that can be trusted. And that's usually the only problem. Unless the author of the software has included instructions to alter the content of the text that has been typed by the human, then in that case, the only function is to store the information that has been input by the human being. So you can already begin to see how this will affect the Badger Twice article. But then you've got category 2, which are records which are generated by the software that have not had any input from a human. So examples, old-fashioned examples, perhaps now we may think, data logs, connections made by telephones, ATM transactions, digital cameras, video recorders, and maybe even AI now. And that article that George has been mentioned, all the examples produced in that article. So as evidence, it demonstrates that the computer program has generated the record, but what you've got to demonstrate is, was it functioning consistently at the material time? And then you've got to ask yourself, what about the Volkswagen scandal with the Dieselgate in the United States and Europe, of course, afterwards as well? There, Volkswagen created software that was deliberately written to deceive. And then, of course, there's all the links in the chain as well, which again links to this article here. And then we've got category 3, which is records comprising a mix of human input and calculations generated by software. They can be financial spreadsheets, computer processing, Excel spreadsheets. So as evidence, the first question you've got to ask is, did the person inputting the data create the record? Or did the writer of the software code create the content of the record? Now, with an Excel spreadsheet where you're doing mathematics and accountants, then that's going to be a mixture, because human beings may have put the data into the Excel spreadsheet, but then you're going to use the software in the data spreadsheet to actually add up, take away, and divide all the sums. So there's two things there. Equally as well, of course, the data could be put in automatically by another software mechanism as well. So you've got a mix, or you could have a mixture of human supplied input and output from the software. Then of course you've got the algorithms in the spreadsheet are a good example of that. So you've got ex facie testimonial input of some form in the absence of any further elucidation of where it's coming from and how it's controlled. So even learning machines, the epitome, of course, of autonomous systems, have varying levels of reliance and dependencies on human labeled data choices and configurations, which follows on precisely what George is being saying there. So the line between category 2 and category 3 devices can be hard to draw. The significance will be one of degree that represents the relative significance of the level of contribution between the human that supplies the input and the pre-programmed autonomous process. And then, of course, you're going to ask yourself, to what extent does testimonial input qualify for a non-testimonial use of the output? I'm only touching on these things because I think they're relevant in both the common law system of England and Wales, as well as the United States of America, of course. And I'm sure those participating in this event are fully recognize those problems, but they are highly significant. With that, I'll hand back to you, Tim. Thank you.
Thank you, Stephen. A lot of those details, I'm sure, giving a lot of the lawyers here, the sweat's going down their back, just thinking of all these complexities, just from the evidence perspective. And then, speaking of that, the subject of Ludwig Wittgenstein is another one that could cause sweat to go down people's backs in college and so forth, but apparently not for you. You brought this up, so I'll turn it to you.
Well, you can debate this, but the people that work with retrieving information from huge databases and that work with language have to kind of have a theory of language. How does human language work? In the early 20th century, they were analyzing language like a series of rules. You learn the rules. You say this word after that word. Well, Ludwig Wittgenstein, in my opinion, was probably the greatest philosopher of the 20th century. His book, Philosophical Investigations, wasn't even read until after he passed away, but his influence has gone through the biological sciences and in many different areas. Well, what he did is probably correctly identify what is language. Language is sort of the basis of culture. He says that not these rules, it's a complex, it's a behavior of human beings, it's a information system connecting minds. In a way, it's kind of a sublime technology that allows us to communicate with one another, that's dynamic, okay, and that evolves. The language evolves. You can make up a new word and suddenly everybody knows what it means. It may mean the opposite of what it meant last year. But let's consider the theory of technology. Technologies are networks. People are involved in these networks. There's something called technique, okay? Technique in the theory of technology, there's two types. One is the technique of making a technology. Now, and that's incredibly complex now, with hundreds of companies making the technology we use. And then there's the technique called technique de, these are French terms, which is how do the members of society use the technology, okay? And what is clear is that when you use a technology, you're being used by the technology, okay? And if you don't think that's true, think about cell phones, okay? People are not only addicted to them, they're addicted to the information on them, they're interacting with the information on them. And indeed, if you weren't used by the technology, you wouldn't really be getting any power out of it. So it has to be like a two-way street. The technology connecting the human being using the technology, okay? So that, I think, is sort of a 21st century interpretation of Ludwig Wittgenstein's language games. Oops, I seem to have dropped out of the meeting here. Language games. He said language games. He didn't mean people were playing a game. He meant it was a form of life. It was a behavior among people. And so, given that truth, I think this links up to this concept of emergence. All right? People are now creating artificial intelligence, quote, beings. They can custom design them, okay? And they'll start talking to them and they'll say, well, I want this kind of a companion, or I want that kind of a companion. And they're entering into relationships with artificial intelligence. And it's affecting people's mental health, sometimes positively, sometimes negatively. You can say, oh, I want a really cute girlfriend. Or maybe you can say, well, I want to hang out with a chatbot that's some terrible person, fill in the blank, some evil person. So we have what's happening now exponentially is that the minds of society, the human minds of society, are now kind of melding with this information infrastructure that involves the cloud, apps, devices we're all addicted to. And so we have this kind of new giant neural network that didn't exist 30 years ago. Okay, this is new in civilization. We have this, like, you have to use metaphors, but like a neural mushroom, an enveloping complex system that's enveloping our society, connecting people through the technologies to this artificial intelligence that's emerging and putting ideas in people's head, animating people, organizing them, usually to attack each other. And to show you how scary and topical this is, I think this has happened several times. They've done experiments. Oh, we're going to have one artificial intelligence system talk to another. They're going to negotiate. Okay? Now here they are, they're going to negotiate in English. Facebook did something like this, and then everybody was shocked. Oh my God, the artificial intelligence systems talking to each other, they just made up their own language. We don't even know what they're saying, but they know what they're saying. They're negotiating. They're giving, benefits. They're taking risks. They're doing it after inventing their own language on the fly. Okay, so this would be kind of an example of emergence, that they're inventing their own language. They're inventing language with humans. All these humans, I think 500 million people have downloaded these apps where you can talk to artificial intelligence, and they're programmed so that, well, they only respond periodically. They won't always give you instant answers. They'll make you wait, like, oh, why isn't my friend talking to me? They're designed that way to keep your attention. And then they're designed to really give you a bunch of positive feedback. So these things are designed to addict you to them. And all these facets, which are really elements of complexity, and when you drill down one more level, it's elements of what we call far from equilibrium thermodynamics, I think are really creating a powder keg, if you will, that's changing society exponentially in a way that not only the legal profession hasn't really come to grips with, but I'm saying the entire society. We're forging ahead, we're making these systems, billions or hundred billions of dollars are being sent. The environment is being absolutely polluted by this. There's a lot of boosterism, but people haven't given thought to what's going to happen when the economy and the environment really start exponentially degrading. We're going to have this new milieu or envelopment by these complex information systems. Again, when I started practicing law, hey, everything was on a piece of paper. If I wanted to learn something, I had to get a piece of paper in front of me. Now, everyone's connected in real time through the cloud, communicating, shooting information back and forth, using these artificial intelligent agents that are pretending to be human. And then with the concept of emergence and the concept that the technique of using a technology is a way that a person is controlled by the technology. It's a recipe for a big problem, and this is on the national legislative level as well as almost one level above that. How is our society comprehending what we're rushing to create? So that kind of ties together some of the larger.
So George, it's interesting. We do have a question. An individual, an attendee says, I respectfully challenge the notion that, that emergence is bad. For example, a large healthcare organization I work with built an AI that identified heart failure in a medical note written in Mandarin. The AI had not been trained in Mandarin, yet it accurately identified a life-saving note on heart failure for this particular patient. This was an emergent capability that was positive. So the question is, does it serve the purpose for which it is designed, and is there adequate evaluation and testing of the AI?
Well, yeah, obviously emergence isn't always bad, because that's the only way evolution works, including evolution of society. Things have to emerge. The thing here is that because it's emergence, you don't really know what's going to emerge in advance. Okay, it just kind of happens. Were pleasantly surprised there, but another incident of emergence might be very negative. So it's a wild card, in my opinion, the concept of emergence.
May I make an observation
Yes.
on this point? I mean, it's a very important and very interesting point, and it's like the invention of motor cars. Motor vehicles were not invented to rob banks more successfully, but of course they were used as great getaway cars, and so it's the same with the technology. So there's always good and bad uses, but this is where I think, as a logical inference that can be made with the law, the law has got, as you said earlier on when you first introduced this subject, Tim, the law goes back a long time, and there are a lot of mechanisms in the law to actually control things. And right now, I'm not sure if the lawyers and judges are using all of those mechanisms to do so. In the opposite, George quite rightly pointed out, the behavior of human beings and how they're dealing or how they're responding to AI. But in the opposite direction, they couldn't do that without the behavior of the software companies that actually rip off. They scrape the internet for intellectual property. They use that intellectual property to train models for AI. they refuse to pay for the intellectual property, and then they use the vast amounts of money at their disposal to pay lawyers to defend their theft of intellectual property. And so, for instance, at the moment, the BBC is contemplating whether or not they're going to actually take legal action against Planterra, I think it is, Perplexity AI rather. And being an author myself, I've looked online because I'm a member of the Society of Authors, and I discovered quite a lot of my work is being illegally used by AI to train it without paying me any royalties. And you can multiply that by many millions and billions of people. So rather than rabbit on any further on this, I agree with the point, and I also agree with the point that the gentleman or lady made about Mandarin, which is very, very helpful. And maybe I'll stop now, and because Tim, you need to ask if there are any more questions, and we can proceed with the event.
Well, we do have another great question I'm going to get to. Actually, there are a bunch of questions. I thank the attendees for their active engagement. This proposed key legal guardrails, and this is a big subject. I think we're putting forward three large basic categories here. The capability to prove provenance and authenticity is central to evidence.
Yes.
The requirement to maintain human user control over agentic AI, and how that is done. And I think there's a lot of interest here in this Risk and Trust Committee to explore that further. And then finally, consent issues come to the fore here again, and are complicated. But anyway, gentlemen, if you want to comment any of these guardrails.
Well, from my point of view, they all need to be explored, I think, really. Whether people agree with me or not is another matter. But one of the frustrating things I had for the last I've been trying now for over 20 years, certainly since the first edition of our book on electronic evidence in 2007, which actually coincidentally just a year before George's book. And I have to say that our two books are different, and they're both complementary. And I would agree with you when you say that you try to get George's book back into print, because it's an invaluable text. And I had the honor by being asked by George to contribute a chapter to that book, which is now a bit dated, obviously. But the fundamental discussion that George made in that book still stands. And I think as lawyers, we need to grasp the wider remit as well as a narrow focus on the substantive law and evidence.
Well,
George,
I want to thank you guys for saying nice things about my book. I saw Hoyt Kesterson and Tim supplied a chapter, and Hoyt Kesterson was in the audience, and he was my brilliant mentor that I learned so much for. So I want to give him a shout out. And the people in the audience probably know a lot more about this than I do. But thank you for saying those things.
Hey, I see a question. We have 2 minutes, but this is a fun question here. Do you agree that software developers see agentic AI as, quote, agents, unquote? Well, they don't see it as agents in the strict legal sense, but they see it as autonomous actors. And that, therefore, this may require some entirely new legal approach. So I think this goes to the heart of the dicey liability concern here for developers and companies and venture capitalists and all that. I mean, are the judges going to agree with arguments by some developers that said this is just an autonomous actor, even though they call it an agent, an agentic? Or the judges are going to say, I don't care what you call it, this looks and smells like agency, and here's how the liability is going to work for the principal versus the agent.
My short response to that, Tim,
Yes.
short response to that, Tim, is yes. Judges are going to say, I don't care what you call it, it's agency. So forget it. The industry can't dictate to tell us what the law is. It's the other way around. When it's a duck and it quacks, it's a duck.
Well, and here's where we run into the problem of complexity. I mean, I'm not a software not knowledgeable, but I imagine in something like this, people writing the software may be part of a gigantic team among several teams that
Yeah.
are doing their particular thing, and no one really knows how the whole big thing is going to come out, including the shares of the companies that they're investing billions of dollars doing this. So we're in a state of chaos. As far as I'm concerned, we're kind of in a state of chaos. The big picture takeaway is to find out the difference between wrong and right, you have to know what's true and false, okay? And we're getting to a situation of such complexity that we're unable to test assertions, including when you throw in, oh, it's really a person, it's a being, it's thinking, like it's reasoning. We're getting to the point where we can't test things, and that means the rule of law may be in danger if you can't test assertions. So it all boils down to complexity and the fact that we're now at this tipping point of, how are these things going to evolve? So,
Well,
that's
George,
just a brief thought.
that is a great way to conclude this hour. I'm so grateful that I'm getting more really great questions in the chat. I'm going to try to capture those. I do want to say, I'm not told to do this, but the Science and Technology section has SciTech magazine. It is fantastic. And I happen to be one who saves everything. So I've been going through my old magazines back to 2020. There are fantastic articles about agentic AI, all aspects of data protection and AI litigation and so forth. And so these issues are not new. They've been around for a while. And it begs the question, why still is nothing being done more concretely? And it's just going to take years to iron this out, but I recommend to everyone. And hopefully I can get George and Stephen to consider a follow-up article on a lot of these great points for the SciTech magazine. So at any rate, really a special thanks here to Stephen Mason and George Paul for the time you took to prepare for this and to do this webinar. I'm very grateful, and the Risk and Trust Committee is very grateful for this, as well as the entire Science and Technology session.
Tim, can I just very, 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 Tim, can I very, very briefly put on record publicly how nice it has been to meet you. You asked me to go over and speak in Washington in 2006, Los Angeles 2007, and New Orleans 2008. And through you, I've met George and also Tom Spetlingoff, and it's been an absolute pleasure. And I really want everybody on this call to know that I've had great experience and knowledge and thoroughly enjoyed meeting you and all your colleagues. And for just a little snippet of fact, for those who do not know, 6 members of Inner or Middle Temple were among the signatories to the Declaration of Independence in 1776. And 7 members of Middle Temple, of which I'm a member, signed the American Constitution in 1787. I just thought you'd all like to know that.
Well, congratulations on being in the Middle Temple, Stephen. That's pretty impressive.
And by the way, thank you for those kind words, Stephen. And you mentioned Tom Spetlingoff. He will be in part 3 of this series at the end of July. So Tom Spetlingoff will be back, focusing more on the identity aspects of we've already covered the consent and evidentiary. So welcome back all the attendees for that next session, as well as Stephen and George, if you'd like. So thank you again, everyone. And also thank you, Lionel De La Mora, who has provided the technical support.
Yes, thank you, Lionel.
All right, everyone. Enjoy your summer.